Bill Barr is threatening to resign his office as AG of America. Tribulation Trump said he's the chief law enforcement officer. Several pardons went forth on yesterday, including the pardon of that Rod Blagojevich and Bernard Carrick, a thug of all thugs, and a host of others, as we are finding now that the Justice Department is being taken over by a tyrannical, despotic, degenerate, pathological liar, con man named Tribulation Trump. What I want to do to you today, I want to, when everybody's focusing on perhaps we're going to lose our standard of justice and nobody can expect the courts to act in a way that is of justice for all in America if we don't rein in the powers that are presently running the administration. I want to read to you a statement of injustices that are being perpetrated against the ATLAH World Missionary Church and its subsidiary, the Appellate Community Baptist Church, right here in New York City, for political reasons and political reasons only. I'm going to read a statement. It's going to take a little time for me to read it. I want you to continue to listen to it, and you're going to see the horrific things that are going on that is being perpetrated against us, as there's an attempt to shut down my voice and to shut down this beautiful ministry that God has put in place. But listen to the various truth. I'm going to read a brief that has been put together by our attorney, Michael Confucione, to appear before the Appellate Division to argue this case on behalf of the alleged water and sewer lien that has been placed against us. And it's to the New York Supreme Court, the Appellate Division, to be argued by Michael Confucione. But Mr. Engineer, I want you to skip to page number 1 very quickly. It says here, the questions presented. Did the Supreme Court err in granting summary judgment for plaintiffs in this foreclosure action and dismissing as a matter of law defendants' objections on standing, prior pending action, laches, and equitable principles? Nature of the case. This is a foreclosure action against the Bethel Community Baptist Church that is parent to the ATLAH World Missionary Church, located at 36 West 123rd Street. The church has been a fixture in the Harlem community for more than 63 years. In addition to teaching scripture and providing spiritual guidance to its members, the church operates a school at the premises, runs breakfast program for after school programs for the children of the community, and houses the homeless. The church is a not-for-profit religious corporation. It receives no financial support from the city or state or any governmental agency. The dispute over water and sewer charges is the next subject. Beginning around 1991, the church had an ongoing dispute with New York City's Department of Environmental Protection over the church's exemption from water and sewer charges. The church maintained that it was exempt from the water. It was exempt under the water exemption statute, chapter 696 of the laws of 1887, as amended by chapter 893 and 894 of the laws of 1980, which exempts religious organizations from water and sewer charges where the property is used exclusively for religious purposes. The Department of Environmental Protection argued that the exemption did not apply because units of the church's property house school teachers and church administrators. Pastor Manning, for example, who lives at the church. This dispute continued throughout the 1990s and into the early 2000s. Meanwhile, the city billed the disputed water and sewer charges to the church, and in 2002 sold a tax certificate to a private party rooted on the alleged accrued and unpaid water and sewer charges. This led to the foreclosure action against the church now at issue in this appeal. The first foreclosure action and Article 78 proceeding from 2003 to 2007. In 2003, a plaintiff named the 1999-1 trust commenced a foreclosure action against the church in the Supreme Court of New York County under index number 104110/20 2003, seeking to foreclose on the basis that the 2002 tax lien that the city had sold for the claimed unpaid water and sewer charges. In response, the church filed an Article 78 proceeding contesting the unpaid water and sewer charges as illegal under New York law, which exempt the church from the charges. The Article 78 Supreme Court stayed the foreclosure action, then in 2004 ruled for the church on its Article 78 petition, affirming that the church was exempt from the water and sewer charges and rejecting the city's argument that the exemption did not apply and that the water and sewer charges were owed. This court, being the appellate court, rejecting the city's appeal and holding petitioner is entitled to an exemption from the payment of water and sewer charges pursuant to statute, although the statute provides that the premises must be used exclusively for religious or educational purposes to qualify for the exemption, and there are residences within the petitioner's church. Those residences are for the church administrator, a teacher employed by the church's school, and thus are incidental to the main and exempt use of the purpose of the property. According, they do not defeat the exemption. And there's an example given here of statutes and laws, including our church, that was brought up in this matter in some earlier court findings. The Court of Appeals granted leave to review and reverse, but only on procedural grounds, ruling that the respondent was improperly denied an opportunity to file an answer to the Article 78 petition. The case was thus remanded back to the Supreme Court to provide the opportunity for respondent, Bethel Community Church. In other words, what's being said here is that both the Supreme Court and the Appellate Court held that the Bethel Community Church, the ATLAH Great Tomorrow's Elementary School, the ATLAH High School are exempt from water and sewer charges. Both courts, the lower court and the higher courts. However, the city filed a petition asking for an opportunity to file an answer to an unanswered question in the Supreme Court decision, and the Appellate Court allowed that, but it never reversed the fact that we are exempt. Continue reading. The court affirmed, rejecting the city's appeal and holding petitioner is entitled to an exemption from the payment of water and sewer charges pursuant to statute, although the statute provides that the premises must be used exclusively for religious or educational purpose to qualify for the exemption. And there are residences within the petitioner's church whose residences are each of the administrator, teacher, school teacher, etc. The Court of Appeals granted leave to review and reverse, but only on procedural grounds. And so we've gone past that. The second foreclosure action and reactivation of the Article 78 proceeding, though the Court of Appeals had remanded the Article 78 case back to the Supreme Court to permit the Department of Environmental Protection an opportunity to file an answer, the Department of Environmental Protection never filed an answer or took any actions upon remand. The plaintiff in the foreclosure action, which had been stayed by the Article 78, took no action either to dissolve the stay or to restore the foreclosure action, which remains stayed and unrestored to this day. And that's back from 2004. Instead, the plaintiff in preceding foreclosure action purported to transfer its right under the tax lien certificate to a second trust, then yet to another entity named the NYCTL 2005-A Trust, which filed a new second foreclosure action in 2009 under this current action index number that we have there. The Supreme Court characterized the plaintiff's transfer as a transfer to itself. The second foreclosure action against the church was premised on the same alleged unpaid tax lien certificate as the first foreclosure action. The 2005-A trust then transferred its right to yet another entity, the 1998-2 trust, the current plaintiff in this action. The church filed an answer to this second foreclosure complaint. The matter then sat for several years in the Supreme Court. Finally, 6 years later in 2015, plaintiff obtained a default summary judgment in this second foreclosure action. A foreclosure sale of the church was scheduled for February in 2016. By order dated August 24, 2016, however, the Article 78 Court Justice Menendez restored the Article 78 proceeding that had been remanded by the Court of Appeals years before and vacated the default that plaintiff had obtained in the second foreclosure action, granting leave to the church to file an amended answer in the foreclosure action. The church filed an amended answer in the foreclosure action on September 6, 2016, contending once again that it is exempt from water and sewer taxes and therefore the tax lien is unenforceable, and asserting the following affirmative defenses. And for a second affirmative defense, prior actions pending, namely the Article 78 on the Supreme Court index, as you can see here, as a prior foreclosure action commenced on the Supreme Court index and the same index number. Number 6, as for a third affirmative defense, plaintiff is seeking to realize a return of 18% compound daily, a usurious rate as applied in this case, and a rate of interest not allowed by law. Number 7, and as for a fourth affirmative action, plaintiff has acted inequitably and has unclean hands, among other things. The bank failed to disclose the prior related cases. The bank failed to disclose the prior related cases into the court and commenced this action despite a stay of its prior foreclosure action based on the same tax lien. Number 8, and as for the Fifth Amendment defense, plaintiff is guilty of laches, waiting 7 years to commence this action in order to obtain an excessive amount of interest, making it impossible for the church to redeem. Number 9, and as for a sixth affirmative defense, a public auction will be inequitable and prejudicial to the parties. Number 10, and as for a seventh affirmative defense, the church is exempt from water and sewer taxes, and therefore the tax lien is unenforceable. And number 11, and as for an eighth affirmative action, this action was commenced by an improper party, the NYCTL 2005A trust, who was never the holder of the tax lien certificate. And the purported assignment of the tax lien certificate to the plaintiff NYCTL 1998 trust is defective and of no force and effect. Therefore, the plaintiffs do not have standing to maintain this action. The foreclosure action was stayed pending resolution of Article 78 proceeding. The Supreme Court, Justice Menendez, departing from the prior decision of the Supreme and the appellate courts in this case, ruled for the city that the church owed the water and sewer charges levied against it. Petitioner failed to show entitlement to a mandatory water and sewer exemption for the entire property, including all of the apartments. This court affirmed the Supreme Court's ruling. The summary judgment decision in the foreclosure court following the appellate division on May 2019 division of the Article 78 case. The matter returned to the foreclosure court. Plaintiffs again requested summary judgment and dismissal of the church's answer and affirmative defenses. The church opposed, contending, among other arguments, the plaintiff lacked standing, failed to pursue the already pending foreclosure action from 2003, and was guilty of laches for delaying this case so many years and causing a windfall of interest at 18% compounded daily, making it impossible for the church to redeem what was once only $36,000 in contested water and sewer charges. The Supreme Court Justice Arlene Bluth granted plaintiffs' motion for summary judgment. And this is where we need to look strictly at the Justice Department in our city and across our nation. Justice Arlene Bluth just completely blew away all of this, ignored it, acted as if our arguments had no merit whatsoever. You'll hear me read. Plaintiffs established standing to prosecute this case by detailing a chain of titles to the tax lien, the court said. The court also declines to find that the doctrine of laches applies. Appellate contributed in delaying this case by asking the court to wait for the Article 78 proceeding to finalize. The fact is that plaintiff obtained a judgment of foreclosure and sale in January 2016. The property would have been sold at auction if Appellate had not sought to vacate the judgment. That is absolutely just an outright slap in the face by Judge Bluth. What were we supposed to do? Not stay the action of 2016? And we're now being blamed for trying to save our church, which was our legal right? The court takes no issue with Appellate effort to get involved in this case. The court merely finds that the laches does not prevent the court from granting summary judgment where Appellate contributed to the lengthy delay in this matter. We did not contribute to the lengthy delay. And if we did, it would have only been 1 year out of 6 years that the plaintiff delayed in pursuing this action. Now that the First Department, the Article 78, has ruled that the water and sewer charges are proper, the court finds that plaintiffs are entitled to summary judgment. There is no dispute that Appellate failed to pay the charges and Appellate failed to raise an issue offset in opposition of its affirmative defenses. The court agreed with the church that it could not confirm the referee's 2015 report, however, appointing a new referee to perform a calculation of the amount due to plaintiffs. The church's appeal from the Supreme Court decision of June 8, 2019, order granting summary judgment for plaintiffs follows here in R3. The argument. The Supreme Court erred in granting summary judgment for plaintiffs on their foreclosure claim and dismissing as a matter of law defendants' objection on standing, prior pending action, laches, and core principles of equity. And here's our argument. The proponent of the summary judgment motion must make a prima facie showing of entitlement to judgment as a matter of law, tendering sufficient evidence to demonstrate the absence of any material issue of fact. And there's a case citing of Alvarez versus the Prospect Hospital. Generally, in moving for summary judgment in an action to foreclose a mortgage, a plaintiff establishes his prima facie case through the production of the mortgage, the unpaid note, the evidence of default. And then there's a Deutsche Bank example given as well. Number one, summary judgment was improper because there was a standing issue raised by the record below. A plaintiff has standing in a foreclosure action when it is the holder of the assignee or the underlying note at the time the action is commenced. And there's a reference here legally that gives binding leadway to this. In other words, Judge Bluth ordered that we are the ones that made the case go on so long when we did not. We only intervened when our church was put up for sale back in 2016. But the plaintiff did not bring this case for 6 years. They sat on it. And at 18% interest per day, The interest grew from $36,000 to now $2.4 million. Now they're ready to foreclose. After the interest has grown so high, it makes it impossible for us to just pay out of pocket, which we probably could have done with the $36,000. They delayed it, but the judge said we're at fault. The judge is blaming the victim. I've never seen anybody like this judge who is blaming us for this delay, who's blaming us for the fact that the amount has gone up to $2.4 million. But our argument is this, is that the plaintiff did not have standing for these reasons. The lien itself, the note, was transferred from the 1999 trust to the 1998 trust to the 2005 trust and back to the 2000, and then on to people we don't even know who the trusts were. And you're going to hear me read that. A plaintiff has standing, and I just read that, okay. Paragraph number 2. Where standing has been raised, as it was by the church in its amended answer filed below, the plaintiff must prove its standing in order to be able to be entitled to relief. And there's a bank reference there. Dispute issues of fact concerning plaintiff's states as holder or assignee on grounds of denial of summary judgment for the plaintiffs. I'm again another bank reference. Copies of 2 different versions of undated, alone purportedly affiliated to the note pursuant to the USC law. Okay, these are all statutes, legal issues where the courts have ruled in cases such as ours that the bank or the assignee did not have a legal standing to act foreclose, so the cases were dismissed. And we presented that information. The same as these statutes that you'll see in this column applies to us. Going down to the last paragraph. Here the plaintiff alleges that the tax lien that the plaintiff is seeking to foreclose is based on a tax lien certificate dated from June 2002. The 2002 tax lien certificate does not relate to the church premises, but a review of the affidavit in support of the motion of summary judgment and the assignment attached to it shows that the NYCTL 1998-2 trust, the current plaintiff is in action, is not the owner of the 2002 tax lien. In other words, this statement states that the tax lien that they're using, the certificate that says that we owe the money, does not identify us as a church. It identifies some other institution, Ace Wire Company. They are using a tax lien certificate to Ace Wire Company. It doesn't relate to us. And yet the judge let this go through. It's absolutely, I'll read it again. And well, you're going to hear me hear me read it in another way. The Marino affidavit submitted by the plaintiff below refers to a tax lien sought to be foreclosed as of 2005 tax lien. The 2010 assignment from the 2005 A trust to the current plaintiffs identifies the tax lien as being assigned as that certain tax lien certificate, and it gives the record and dates number. However, that is not the tax lien set forth in plaintiff's complaint. The record below did not contain an assignment for the 2002 tax lien to the current plaintiffs in this action. The 2005 tax liens assigned to the 1998-2 trust are not the 2002 tax lien certificate. A review of the 2 tax lien certificate assigned to the 1998-2 trust shows that these 2 tax liens are for other properties and have not been recorded against the church property. You see that? They're going to court with tax liens that have been signed to other properties that are not our properties. And yet this judge said she don't care. Foreclose the church. It's unbelievable what they're doing. It is absolutely unbelievable. And it's plain. And they admit it. That the tax lien that they're using is not against our church, but they're using something against some other organization to foreclose us. And the judge didn't throw this case out on his face. She ordered, take the church. Anyway, A review of the two tax lien certificates assigned to the 1998-2 trust shows that those tax liens are for other properties and have not been recorded against the church property. Plaintiffs failed to prove standing as a matter of law, as required to obtain summary judgment to foreclose. Timing of the assignment is critical for the plaintiffs to demonstrate standing sufficient to obtain summary judgment. The assignment to the plaintiff must be complete when the action is commenced. Again, the Deutsche Bank, and their references there. If an assignment is in writing, the execution date is generally controlling, and a written assignment claiming an earlier effective date is deficient unless it is accompanied by proof that the physical delivery of the note and mortgage was in fact previously effectuated. In other words, well, you'll see what happens. Summary judgment is improper with these demonstrations by the plaintiff. And it goes through several banks, the National Bank and the Wells Fargo and Countrywide Home and Loans and a bunch of other LaSalle Bank, indicating that the way that they have come up with the assignment of the tax lien is improper and has been defeated in many, many courts. And so therefore, they lack standing. Down at the bottom of the page, just after the words, the letters 2012, reversing a trial court's denial of motion to dismiss for lack of standing, finding no standing, where corrective assignment relied upon the plaintiff had no retroactive effect, and where there was no evidence of prior physical delivery, and where both the unrecorded initial assignment and the recorded corrective assignment reflected assignment of only the mortgage and not the note. Plaintiff's records presented on summary judgment in this case were insufficient on the standing issue. That is regarding our case. Mark Marino, who provided the affidavit in the support of plaintiff's demand for summary judgment, has been the servicer only since 2013. He does not have personal knowledge of assignments that allegedly occurred years before, dating back to 2002. Marino failed to comply with the business records exception to the hearsay rule because the documents he cited were not created by the company for which Marino is director, which is the MTAG Services. Plaintiff's record keeping is further suspect since it claims it was unaware of the first foreclosure action commenced in 2003 and has produced the wrong assignments while swearing that they assigned the 2002 tax lien certificate. He's lying. The affidavits filed by plaintiff and its attorney below are inconsistent with each other and with the plaintiff's complaint. The Marino affidavit alleges that the first entity, the Newark NYCTL 1999 Trust, purchased the 2002 tax lien certificate in 2002, and that it was assigned to the 2005 A Trust on June 1st of 2005. And that it then was assigned back to the 1998-2 Trust, the current plaintiff, by assignment recorded on June 29, 2010. But plaintiff's complaint alleges that the bank is holder of the tax lien certificates for the 2000-5 Trust, the original plaintiff when this foreclosure action was filed in 2009, as evidenced by a certain tax lien certificate, the 2002 tax lien certificate. The complaint does not mention the 1999-1 trust or alleged assignment of the 2005 trust. The complaint alleges that the 2005 A trust is the original purchaser of the 2002 tax lien, which is contrary to Mr. Marino's affidavit submitted in support of the summary judgment and below. In other words, what's happening here is that they can't find the right note. They can't find the right papers. This thing is so old that it started back in the 2002, and then for whatever reason, the 2002 tax lien was then transferred to an earlier 1998 trust tax lien. They became the owner of it. They could pursue. It was then transferred from 1998 to the 2005. In 2005, the 2000-5 trust became the owner of it, and then they were able to foreclose, and everybody else had been excluded. Then the 2005 allegedly transferred it back to the 1998 A trust. Then the 1998 A trust transferred it to the 2009. And then finally, by the time it gets to the courts, the properties listed are not the Appellate Church or the ATLAH or anything that we own or any of our properties. So what happens at the servicer, the reason why there's all this confusion is that they kept transferring it because they didn't have the right data and information back in those years. And the servicer that held this tax lien up until 2013 went out of business. All their records went defunct. So they sold it to a servicer called MTAG. And Mark Marino is the director of that agency. So he was brought into court to testify. Is this an authentic, original? Can you trace the history of this back to 1998? And he says, no, I cannot. Do you have records demonstrating that this is accurate, prima facie accuracy, that this lien is accurate, that the recording of this lien is accurate, and that the transfers and the holders of all these liens through the 2005, the 2002, the 1998, the 1999, back to the 2005 A, can you demonstrate with accuracy that you have the records, understanding that the transfer and that the numbers and the calculations are correct? He said no. Do you have any personal knowledge of the company that had these tax liens? Again, the answer is no. It was just sold to them, and all they have is what was sold to them without any supporting evidence. And yet the judge said, it's okay with me. I mean, can you believe this? I mean, can you believe this? I'll read more. The affidavit of Megan Meyer, sworn to on April 17, 2015, which plaintiff submitted to the prior referee as an affidavit of debt, shows inconsistency with plaintiff's documentations too. Ms. Meyer alleges that the 2002 tax lien was transferred to the Bank of New York Mellon without referencing any trust at all. It's impossible. Ms. Meyer then alleges that the 2002 tax lien was assigned on August 8, 2002 by the 2005 A trust to the 1998 trust, which again is contrary to Mr. Marino's affidavit submitted in support of the summary judgment. In other words, they got two conflicting, one person said one thing, another person saying another thing. You get the idea. Mrs. Meyer's affidavit is further suspect since the 2005 A trust was not allegedly created until May of 2005. She said that it existed before it was actually created. The affirmation of plaintiff's counsel submitted in opposition to the church's motion for stay also recites a different chain of title that shows further why summary judgment on standing was improper. Counsel alleged that the tax lien sought to be foreclosed was sold and assigned to the NYCTL 2002-A trust, then assigned to the 1998-2 trust. Counsel alleges a different purchaser of the tax lien, not referred to in the 2002 tax lien, and fails to explain how the 2002 tax lien certificate was allegedly transferred from the 2002 A trust to the 2005 trust. Unlike in the NYCTL 1996-1 trust, plaintiffs in this case failed to establish whose benefit the bank was holding the 2002 tax lien certificate. Moreover, the servicer in this case, VS Director Mr. Marino, admits it became the service of more than 10 years after the assignment of the 2002 tax lien certificate was alleged to have occurred. Mr. Marino has no personal knowledge and has produced insufficient documentation of the assignments of the 2002 tax lien certificate. The records that plaintiffs claim were transferred to the servicer were not demonstrated to have been made in the ordinary course of business, where thus hearsay and where thus improper ground on which to grant summary judgment for the plaintiff on this critical standing issue below. Business records exception to the hearsay rule. In other words, they don't have records. They're just saying they don't have proof. The plaintiff is submitting a hearsay, somebody to say, I think that's what it is. And the judges and the courts, the law says you can't do that, except if you have prior knowledge. Then you can say, I saw them, I'm familiar with them, I serviced them. But here, there is no such testimony. He's just saying, well, this is how we received it, cold bear. We had no prior understanding of it. In other words, so how can you foreclose on something as skimpy as that? But Judge Bluth said, she don't care. Take the church. Last paragraph. Another ground for reversal is that the alleged 2010 assignment from the 2005 A trust to the 1998 trust, the current plaintiff in this action, shows that the 2005 A trust, even if it were its owner of the 2002 tax lien, did not assign the 2002 tax lien to the new NYCTL 1998-2 trust. Rather, the assignment identifies two other tax lien certificates that were assigned. And that tax lien certificate number JA, dated 27th of July 2005, recorded on July 27th, that tax lien certificate JA, again recorded on August 16th, 2005. The record submitted on summary judgment does not contain an assignment of the 2002 tax lien to the plaintiffs of the 1998-2002 trust. The two 2005 tax lien certificate assigned by the 1998-2 trust have nothing to do with the 2002 tax lien on which plaintiff seeks to foreclose. The Supreme Court erred in granting judgment on plaintiffs. In other words, when Judge Bluth granted the plaintiffs a judgment of foreclosure, it's ridiculous, it's impossible. It was only out of a sense of political injustice, because even you that don't understand law, and perhaps some of these assignments and tax liens and certificates and legal precedents can be a bit confusing, it is clear that something in this ain't right. There's something wrong here. And you don't take somebody's property from them with as many errors and mistakes as there has been demonstrated in this particular foreclosure proceeding. And a judge who understands these laws clearly, you were just barely trying to keep up with me. A judge and a lawyer understand these clearly. And it's an outrage. It's an outrage that this judge says she does not care. Foreclose and take the church. And if there was some mistake, you would rule in favor of letting the church stand and letting the bank that makes all the money, the bank that makes all, you would say, let the bank suffer and let the church go free. You would think that's what she would do. But not when the church is led by Pastor James David Manning, and it's in Harlem. And all of the gentrification and gentrifiers that have come up here, and all of the property is now at stake. If Manning can continue to exist, if Manning and his church can continue to exist, then everybody's well-being is at stake. Shut him down, take the building, run him out of town, even though it is clear that the bank has no standing, that the documents are forged, and that they're old. But that's not all. I want to read more to you. The Supreme Court, in the second paragraph, erred by granting judgment for plaintiff on standing, where the record submitted below shows that there were at least disputed issues of fact. where plaintiff is confused or mistaken. The inconsistencies in the record on what assignments were made and when they occurred show that plaintiff failed to demonstrate standing to foreclose as a matter of law with regard to the 2002 tax lien on which it seeks to foreclose. The court should reverse the Supreme Court's June 8, 2019 decision order granting summary judgment on the plaintiffs on this ground, on the Deutsche Bank example. I'll be through in just a moment, but I want this to be as a record so people can read it for themselves, they can listen to it, and it may be a little difficult, the legal jargon, but you need to see what they're doing to us. You need to see. And again, I want to reflect on what's happening with the Justice Department and with the Attorney General, with Tribulation Trump, and people who are guilty getting off free, and people who are innocent are being persecuted and thrown into prison. You need to see that this has been going on in America, and we have become a victim of that process. And you need to know why I'm standing so clearly and why I need you to read this and share it with your friends. If you have lawyers and maybe students in law school, anybody, just share with them and let them see what they're doing to us. We have not failed to pay our bills. We don't owe the money. And the case is so old that the records are frayed, they're inconsistent. There are two people giving two different testimonies, inconsistent about the case. In a matter like that, any normal person would have dismissed this case, but not Judge Bluth, who is the head of every LBGT community and office. She's the president of the Women's LGBT. She's president of the Youth Gay Movement. She right here in New York City, but she sits on the court. She should not be able to sit on a bench with such a rampant runaway bias towards the LGBTQ community. Yet she sits there, and the court lets her sit there. And that's why we have these rulings that are so unfair. I mean, if there was somehow or another, it appeared that we possibly owed the money or that we were guilty, then perhaps. But to rule in favor of the bank with all of this that's being leveled here before the courts, and this is a sworn affidavit, and yet she ruled against us. You see the battle that we're up against? And you need to come to understand that if they are doing this to us, they'll do it to anybody that they, and Trump is doing it all over the place. It must be stopped. Let me continue to read, because there's just some other tidbit of information I want you to get, and then I'm going to let you go free today. The plaintiff's complaint is properly dismissed where a pendentive action existed between the same parties, essentially the same relief and involving the same enforceable act. In other words, what our attorney is saying, we have an action going back to 2003 that's still pending. It hasn't been resolved. It's still stayed, meaning that no court, no action, no lawyer, no anybody can do anything against our church because the 2003 court action is still standing. It has not been adjourned. It has not been adjudicated. The stay is still in place, commanding nobody to take any action. Yet the Bank of Mellon started a new 2005 NYCTL trust and started a new action on the same tax lien. And what our lawyer said, you can't do that. You can't, because one is against you. You don't go back to that one. You start something brand new as if the courts don't know. And that's what's going on. You see what I'm fighting against? In this case, when plaintiff commenced this foreclosure action, there was already a pending foreclosure action, the 2003 foreclosure action, that had been stayed but remained pending. Both actions seek identical relief based on the same alleged default under the same 2002 tax lien. The prior action was commenced under an index number. The prior action was stayed by Justice Payne, dated on the 14th of June 2004. The prior action was never dismissed or adjudicated, nor was the stay vacated, even to this very day, from 2004 to 2020. The 2005 A trust, the original named plaintiff in this action, seemingly ignored the prior pending action and commenced a new action seeking identical relief 6 years after the first action had already been commenced. Plaintiff's argument below that it was unaware of the first foreclosure action does not mean that the prior pending action case law cited above does not apply. And again, throws doubt on the plaintiff's demonstration of his standing to foreclose in this action. Mr. Marino, on behalf of the servicer, claims to be fully familiar with the file and maintains all records regarding the 2002 tax lien. However, then, the servicer was not aware of the foreclosure action was already filed and was still pending on the same tax lien. So how could you have known everything if you didn't know that? The Supreme Court erred in dismissing the prior pending action defense and failing to dismiss plaintiff's complaint on this ground. You know, I'm not going to be, for sake of time here, I'm going to skip over the laches issue and go to page 19 on the summary judgment was improper on equitable grounds. A foreclosure action is equitable in nature and triggers the equitable powers of the court, and it has several legal binding cases to state that, to make that case. A court, down at the bottom, a court may rely on its inherent authority to vacate a judgment in the interest of substantial justice rather than its statutory authority. In other words, the courts can look at this and say, you know, the law says one thing, but the equity here, who should get the benefit? Should the bank get the benefit and they get paid the $2.4 million, or should the church get the benefit? And we'll just dismiss it. The court has the authority to do that. They can choose one or the other if there is a question. This court chose the banks. You see? I mean, it's not like we're a manufacturing company or that we are a major producer of goods and making millions of dollars. We're a church, we're a school, and a homeless shelter, and a breakfast program. And yet the court, Judge Blue, chose to honor the bank and not the church. Absolutely unbelievable that she would do that. That she would make a decision on behalf of the bank. He's talking about equity. Is that fair? Anyway, as summarized above, the church and the city had a legal dispute about whether the church owed the water and sewer charges. The church contended that it did not owe the water and sewer charges because it was exempt under New York law. And the city contended that the charges were valid and due. But until 2017, no court or any other legal authority held that the city's water and sewer charges were lawful and owed by the church. New York law did not support the city's argument that the religious exemptions did not apply when the city levied its water and sewer charges on the church or when it sold its 2002 tax lien. When the New York court did rule on the substantive issue, the courts ruled that the water and sewer charges leveled against the church were not valid. Justice Cornwright, in her 2002 decision in the Article 78 pending, affirmed that the church was exempt from water and sewer charges. The Court of Appeal agreed, holding petitioner is entitled to an exemption from the payment of water and sewer charges pursuant to statute, and that the charges the city levied were invalid. And though the Court of Appeals reversed, the court did so only on procedural grounds, that the respondent was denied an opportunity to file an answer to the Article 78 petition. The Court of Appeals did not address the substantive ruling that the Supreme Court and the Appellate Court had made that Bethelite didn't owe the taxes. It was not until 2017, 15 years after the city issued its tax lien for the water and sewer charges, that New York court finally ruled the city's charges were valid under the law. Yet, plaintiff's foreclosure action in this case is premised on running 18% interest compounded daily on water and sewer charges that until 2017 were deemed invalid under New York law. It is the running of the 18% interest rate from 2002 that the basis of the plaintiff's attempt to take this Harlem church property. Is it legal and equitable under New York law for interest to occur on a claimed debt during a period of time that the New York courts held that the debt was invalid and illegal? And the answer, of course, is no. Plaintiff argued below that the 18% interest rate, accounting for nearly all claimed indebtedness owed by the church under the tax lien certificate, is statutorily mandated rate, is a statutorily mandated rate of interest that a court cannot modify. But the taxes must be due in the first place for interest to begin occurring. Interest on unpaid taxes for tax or real estate taxes which shall become due and payable, emphasis added, though the city billed the church for water and sewer charges that culminated in the 2002 tax sales certificate, these charges were not deemed valid until 2017. And until then, the Supreme Court and this court ruled that the charges were not lawful under New York law. How can interest be deemed to have occurred on an alleged debt that until 2017 was ruled as unlawful under New York law and by New York courts? How can interest be deemed to have occurred when the principal was not due and payable under New York law? So, this is the core equity visited on the church in the foreclosure action and further ground on which the reversal of the Supreme Court's grant of summary judgment law. As Pastor Manning affirmed to the Supreme Court in opposing plaintiffs' demand for summary judgment, and I quote, "We faithfully applied for exemption from water and sewer taxes because we were assured in our belief by virtue of our charitable mission and community service that we were exempt. I am confident that you are aware that we hold a full tax exemption of property and sales tax from New York City and New York State. Since purchasing the property premises in 1984, the church has been exempt from real property taxes and has been charged. The church has been exempt from real property taxes and has been charged and paid 0 real property taxes per year since then. Our belief and work was affirmed when Justice Kornreich issued her judgment declaring us tax exempt of water and sewer charges. To issue a foreclosure judgment against us would shudder our lives. The kindergarten through high school children would be forever scarred. The homeless shelter residents would have to return to New York City shelters for help. The community children's breakfast program will leave thousands of Harlem's children hungry. The 14 full-time employees will be out of a job. The congregation will be devastated and perhaps never to regain their faith in Christ or the courts. Please be mindful that we do all this work without any city, state, or federal funding or support. The consciousness of men ought to remain free and unshackled, said one New Amsterdam city official during the days of Peter Stuyvesant. I can't believe that the city fathers meant for this tax to destroy the lives of families and children who want to act honorably. That's a statement I injected. And so I want to wrap it up here. I wanted to read this. I know it's it's not a little bit, it's very legal. And trying to make it plain is even more difficult. But going forward, I want this particular video to be available to anybody who wants to sit down around the kitchen table and discuss it. You have both my horrible reading, and I apologize that it is so horrible. I'm not the best reader. But you can read it yourself, and you can then, if you like, I can send you a printed copy if that's what you would want as well. There are so many things about this particular item that the average normal person would have just dismissed this case years ago. But Judge Bluth wants to see us shut down. And we need to understand something about the battles that we're fighting. Not we're going to win. We are. Because we've taken this matter out of Judge Bluth's hand and put it into the hands of 5 judges on the appellate court. It is unlikely that they will agree with her. Very unlikely. It is more likely that they will see the injustices that's being perpetrated by us. But we must take affirmative action. We must oppose this summary judgment. We must also oppose another judgment that came down in January of this year of foreclosure and sale. We must oppose that to the appellate division. We must also oppose that our civil rights were violated in several issues, and we must take this matter also into the federal court. So we're going to need 4 distinct lawyers. The lawyer that wrote this particular brief does not do trial. He only does appellates. The lawyer that's doing our foreclosure and sale brief does trials. Now we need a lawyer to deal with the federal issues at hand here regarding banking, taxing. Can you tax someone? Can you charge interest on someone on a debt where both New York court says the debt is invalid, but yet interest is being charged on an invalid debt? There's a lot of work to be done. We're going to need a ton of legal money, and it will be worth it. And we're asking you to begin to pray about this, share it, talk about it. And there'll be people that will hate us. There are people that are praying that somehow or another that we lose and that the vision of ATLAH could be swept under the rug by the stroke of one judge's pen. They don't want to see us proceed. And many of these people are primarily people who just want to participate in gay lifestyles and marriages. And they feel that I am a threat. So understand, it isn't just from the courts that we're receiving this. It's from some people that even a lot of people that smile in my face want to see me go down. That's why it's important that we read Psalms 37, verse 23 through 29, that I will never be defeated and I will never be destroyed. I'm James David Manning, everybody. I'm the Lord's servant, but I need your help and your prayers. I'm going to ask for donations for our legal fund to hire these 4 lawyers. We'll need approximately $100,000. But the Lord will bless everyone who gives.